Good morning, everyone. I welcome you for today's session. I am Aakash M.Nair, Assistant Professor at IIMT College of Law. Today, we are going to learn about a topic that is related to jurisprudence and also philosophy, that is legal rights and legal duties. So, when we discuss about today's topic, we will be discussing about what is legal right, what are legal duties, how it has been interpreted by various philosophers, various jurists, right? Let us take an overview of this topic. So in this session, we are going to discuss about emergence of legal right, relevance of a legal right, meaning and the components of legal right. That is, what are the components of the legal right, how it has been defined by various philosophers. Then the elements of legal right. So we have certain theories which defines the elements of legal rights. So it is the protection theory, will theory, and the interest theories. And then at the end of the session, we are going to discuss about the right and duty conflict, right? So let us start with the emergence of legal rights. So there has been a movement at national and international level for respect to individual freedoms and his dignity against the arbitrary acts of political society or state itself. And it is a very contemporary issue. It is national and is prevalent at international level as well. During the age of Renaissance, that is from 16th century to the 18th century, Hobbes, Locke, and Rousseau propounded the theory of social contract to stress the sanctity of individual rights and individual freedom within a given political frame. So these are the philosophers who have discussed about the individual rights and the individual freedom within a political framework in the 16th and the 18th century. Then in the 19th century, Kant, Mills, Spencer, and Darwin laid emphasis on the rights of individuals and which resulted in conflicts and social upheaval. Now, under the New World Order, that is post World War II, attempt is being made to establish and maintain a stable legal system in politically organized society, which guarantees, and what does it guarantee? It guarantees certain legal rights to individuals within the social order established by law, right? So as we can see, before the World War II, there were a lot of social movements. First, we had we know about the American Revolution. We also know about the French Revolution, right? So and we witnessed the World War I and the World War II, and lots of lives have been lost because of that. So it was high time that we maintain a stable social order. For that, certain attempts were made. And what was the ideal that was accepted? That is, certain guarantees or certain rights will be given to human beings, right? So we will discuss about it further in next slides. Importantly, a man without right depends completely on the whims and caprice of others, is not a normal being and perhaps maybe a slave. So this is the basis of human rights, right? That if a person does not have rights, then he is dependent on the whims and caprice of other person, a person who is more powerful than this person, right? Then he will be a object or a puppet of that person, right? Now let us talk about the relevance of a legal right. So in the 21st century, the right duty conflicts has deepened and is debated by most of the democracies. Recently, the Prime Minister of India advised the youth to focus on walking on the path of duties and spend less time talking about rights, fighting for the rights, and wasting time. So this was a very important statement that the Prime Minister has made. And even in many of the countries, we can see that the leaders are talking that that its citizens should focus on legal duties rather than asserting their legal rights again and again. So there is a conflict with respect to the legal rights and the legal duties. We will discuss about this conflict in the coming session, in the upcoming slides. On the one hand, The supporters of the Western liberal thought values are asserting that a legal right of an individual should be given primary consideration in a legal system. Whereas, on the other hand, the supporters of conservative thought are supporting the view that common interest of the society should be secured by imposing legal duties on the individual. So there is a stark difference in the approach as to what has a primacy, what should be given more importance, whether it is the legal right or the legal duties. If we see the Western culture or the Western society, we can see there is more assertion of legal rights. There is more emphasis or more importance is given to legal rights. Whereas in Eastern societies, that is China, India, and the other South Asian countries, the more emphasis is with respect to legal duties, that a person should focus on carrying out his duties rather than asserting his duty. It is said that if a person genuinely follows through his legal duties, then the legal rights will be attained by him eventually. Since he is completing his duty, vice versa, some other person will uh, carry out his duties. In eventually everyone's rights will be fulfilled, right? So whereas on the other hand, the supporters of the conservative thought are supporting the view that common interest of the society should be secured. So the more interest, the more importance is given to the common interest rather than the individual interest. So a legal right is considered to be an individual interest. It can be a collective interest as well, but when there is a conflict between the individual interest and the common interest, then the common interest will be given primacy. This is the conservative thought, right? Therefore, it becomes necessary to understand the meaning, components, and essentials of legal rights to have a better understanding of this topic, right? So let us now look at the meaning, components, and the essentials of the essential elements of the legal right. So let us discuss the meaning of the legal right. Right, the term right is derived from the Latin word that is jus or rectus, which means which is straight, something that is straight, not crooked, in opposition to wrong. So it has been seen as an opposite to wrong, which is twisted from straight. In ethics, right means which is in conformity with morality. So whatever is which is in conformity with morality, that is right. And so is morally good, a non-legal definition. We have to understand that this is not the legal definition of right. This is the non-legal definition of right, which is given in ethics and morality. Now let us understand the definition of right in legal sense. Now, existence of some capacity or power or freedom in an individual to hold, act, and exact something in society, which its power and permission by which others are refrained from acting contrary to the detriment of such person. This definition has been given by Holland. Now, what does this definition say? It is saying that there is an existence of some capacity or power or freedom in an individual, right? What does that power gives you? It gives you the power to hold, act, or exact something in society, making something possible in society. You have that capacity, you have that power. So you can ask some other person or you can direct some other person to do something, right? So it is we can make it parallel with power and permission as well. And the other person now is refrained from acting contrary to the your desired act, right? If you have a right, then the other person is refrained from violating your right. Now let us understand the second definition, which is given by Roscoe. According to him, a right has five analogous meanings. So let us see what are the five analogous meanings. Firstly, an interest secured and protected by law. So what is a right? Right is an interest secured and protected by law. Secondly, a right is a claim to act or forbear others to make the interest effective. So we can see that the second definition is very much similar to the first definition given by Holland, right? Now the third analogous meaning. A legal right is a capacity or a power of creating, divesting, or altering rights. We can see this right in the property rights, right? A person here may have vested rights or he has inherited some properties. So that we can compare in this also. So that that person can create, divest, or alter his rights with respect to that property. The fourth definition is regarding non-interference by others. So it is significant that if a person has a right, then there has to be non-interference by others. Other person cannot infringe on that right. Right. Fifthly, right has been compared with justice. That is, which recognizes and give effects to moral rights. Right. Which has been recognized with justice, which recognizes and gives effect to moral rights. Right. Now let us see the definition about Eyring. Eyring has given a very short definition, that is, right is a legally protected interest. What is right? Right is a legally protected interest. Right. So continuing, legal rights are rights. Now if you put it in a simple terms, legal rights are rights which is recognized and enforced by law. Right? Who is recognizing that is the law has recognized and it is enforcing the rights. These rights are legal rights. It has a binding character and enforceable by the courts, even though it may be in conflict with morals or ethical rights. Right? According to Paton, the test of legal rights is an easy one. It is the right recognized and protected by the legal system. So there are two terms that is very important. That is a right recognized and protected by the legal system, right? Or the law. According to Salmond, a legal right is an interest. We have talked about this earlier also. A legal right is an interest recognized and protected by a law, by a rule of legal justice. An interest, the violation of which would be a legal wrong done to him, whose interest is and respect for which there is a legal duties to others. So what is, if a person has a legal right, then what is the we can say the jural opposite, that is the legal duty. The other person has a legal duty not to violate or not to infringe on the right of that person. Now let us see what Julian Stone says about it. So legal right is a claim justifiable in words, and the existence of legal right presupposes existence of a remedy for its breach. Right? We have read it in the maxim also, that is ubi jes ibi remedium. That is, where there is a right, there is a remedy. So what is it saying? That the existence of a legal right presupposes existence of a remedy for its breach. So if there is a right, then there will be remedy as well for that breach. Right. Now let us take a case of an example. Let us take a case, that is Daniel Harley Walcott versus State of Madras, 1968. The Madras High Court defined the term legal right. What does it say? Legal right in its strict sense is an actionable claim. Legal rights is in its strict sense is an actionable claim enforceable before the courts and administrative agencies. So it is, what is legal right? It is an actionable claim. Right? In the wider sense, it is an advantage or a benefit conferred upon a person by rule of law. Right? In a wider sense, what is it? It is an advantage, benefit, or we can say it is an interest which has been conferred by, upon the person by the rule of law and not the rule of man. This is very important. It is who is conferring the right? It is the rule of law. Right. There are legal rights recognized by law, enforceable by courts. However, there are legal rights recognized by the international courts and granted by international law, but are not enforceable. We can see the two rights, that is, a legal right is recognized and a legal right is protected. But there are certain legal rights, even though they are not enforceable, right? Because of the certain geopolitical situations, it may not be enforceable, but even then those rights are legal rights, right? So in essence, a legal right is a capacity of asserting, securing interest rather than a claim that could be ascertained in court. So so what we can say, a legal right is a capacity of asserting secured interest. We are asserting a secured interest, which includes both, which may include either recognition or enforceability of that. Okay, let us now go through the components of legal right. A legal right involves a series of relations on which they are grounded. For example, a workman having a right to his wages. Now let us take this example and understand this concept of legal right. For example, a workman having a right to his wages. So if a workman has work, then he is entitled to wages, right? Now this right may have five components. What are the components? Let us see. Firstly, the subject. Who is the subject? The workman who earned the wages. Workman. The workman is the subject. The workman who earned the wages. He is the one who is possessing the right or owner of that right. He is the person who possesses that right or is the owner of that right. Also known as the person of inherence. What is he called? The subject is called the person of inherence who has this right. Right? Now, second component is the object. Who is the object? Now, the employer who is bound to pay the wages is the object. So, the subject is the workman, the object is the employer. So, the employer who is bound to pay the wages, right? He is the object. The person bound by a duty, who is an object? The person bound by a duty upon whom the corresponding duty lies, right? Corresponding duty lies, the person of incidence. So the employer is the person of incidence on whom the corresponding duty lies. Because the workman has worked for him and he is entitled to wages, the employer has a duty to pay the wages, right? So he is the person of incidence, the person bound to respect the right. The employer has to respect that right, the right of the workman. Right. Now let us see the third component, that is matter. What is the subject matter? Right. The wages of the work. The wages of the workman is the subject matter. It is that to which one has right. The wages of the workman, right? It is that to which one has a right. So what is it? The right the workman has? It is the wages because he has work, so he has a right. So I'm sorry. Yes, we were on the matter, right? So the wages is the matter. It is that to which the one has a right. It is a thing or a res or a matter. A human can never be a res. So it is an important rider. Can a person be a matter? No. A human being can never be a matter. A human being can never be a matter, right? Now let us see the fourth component, that is the acts. So what is the act? The work done by the workman is the act, right? So for the act, he has done some act, and for that act, he has received some right. He is going to receive the wages, which is now he is entitled to. When was it due? It was due when he completed the act or he was doing the act, right? So the act, the work done by the workman, some positive or negative act. It can either be that a positive act has to be taken. Suppose a workman has been given a task that you have to build this building or you have to shovel this cement. Now, in that, he is positively doing an act, physically doing an act. Or other thing can be he he has a duty to omit some act, that he should not do this act, he will not do this act. So there can be both positive and negative act, right? Which is necessary for the fulfillment of the right. Right. Now the fifth is the title. Fifth is the title. It is the workman who works for the employer. They have an employment contract or they have an employment relationship. That is why, since he is the workman, that is why he is being giving the wages. If a random person does a work for you, will you give the wages to him? No, because there is no employment contract. There has to be employment relationship. Since he is a workman, that is why he is entitled to those wages, right? If a random person comes to you and work for you, that will not be wages. It may be termed as a remuneration or some other thing, but it will not be considered as wages. So title is again important, right? Now There is a note that 1 to 4, that is subject, object, matter, and acts, have been given by Paton and Holland. The fifth component, the title, has been given by the jurist Salmet. Okay. Now let us discuss the elements of legal rights. Now we know that there are three theories on which this elements of legal right has been defined. Now we are going to discuss the first theory, that is protection theory. One of the three basic elements is the protection afforded by the state, right? The protection that the state protects, so state provides, state or the government provides. The source of all legal rights is law, and law creates, recognizes, and protects the rights so newly created. So the state is saying that the legal rights is created by law, is recognized by law, and is protected by law. A right becomes a legal right when it is guaranteed and protected by the state and its legal system. If a legal right cannot be enforced, then it must at least be recognized by law, right? The essential features of a legal right is its vindication through law against any possible encroachment. So the enforceability is the key factor. The essential feature is the enforceability. Our Dr. Bhimrao Ambedkar has said about the Constitution that the Article 32 of the Constitution is the most important fundamental right of the entire Constitution, of the third part of the Constitution. Why? Because it talks about enforceability. It talks about the writ jurisdiction, right? If any harm or any infringement happens on the fundamental rights of any citizens, then they have a remedy to approach the Supreme Court or the constitutional courts, right? Now, what is the exceptions to the enforceability of legal right? First is statutory limitation, which bars enforcement of legal rights after a certain limitation period. Example, statutorily barred debts which cannot be enforced, right? Secondly, there is sometimes courts lack the machinery to enforce a certain legal right arising out of right confirmed by a decree or a judgment of a foreign court. So then we are talking about the exceptions to the enforceability of legal right. Although it is an essential feature, but there are certain exceptions to it. So if the court lacks certain machinery to enforce a certain legal right, then also it will be called a legal right only, even though it is not enforceable. Third, a legal right, although enforceable in strict legal sense, remains on the paper only because of absence of strong responsible public opinion. Right? Even though we have the Child Marriage Restraint Act, we have the Hindu Dowry Prohibition Act, even though still those menaces are still practiced. Why? There is no social, the strong responsible public opinion against it. The society has not changed, right? So these are the exceptions. Now let us understand the will theory and what are the elements of legal rights given in that theory. The main proponents are Kant, Hegel, Hume, who believes that the purpose of law, legal institutions, and the state is to grant the individuals the maximum opportunity for self-assertion and for self-development. Right? So we can understand this. Let us see the theory. According to this theory, there is a perpetual conflict between freedom of one individual with that of other individual and the state as part of natural process. So there is a constant conflict between individuals and the state. If there are two individuals, there will be conflict or assertion of rights between the two individuals, or if there is state, then the conflict may be between the state and the individuals, right? It is natural. It is a natural part of society. However, this process of conflict cannot deny certain basic natural rights of man, which are inherent in him because of his self-dignity and individuality, that is human will. Now, these are the inalienable natural rights, basic natural rights, or we now call it human rights, which cannot be there cannot be conflict with respect to that, right? So the human rights are enforceable, and there may be conflicts, but these rights are inherent in individuals. Why? Because of their human will. Since they are humans, they have a human will, then they are protected by human rights. It is human will which makes a person self-owned, self-possessed, and self-controlled, the master of his interest and the best judge of his own act, in such a way that he cannot be subordinated to the interest of another to be used and controlled by another. So a person becomes his own master and he does not have another master. He has a human will. Importantly, a man without rights, depending completely on the whims and caprice of others, is not a normal human being and perhaps maybe a slave. We have read this statement earlier also, right? Criticism. What is the criticism of the will theory of legal rights? Criticism is, firstly, it is not a scientific and workable doctrine for social harmony and general good. Secondly, it puts the will of one against the others. Therefore, there is a constant conflict between the two wills facing one another in opposite direction. So, by nature, this theory increases conflicts between individuals and focuses on the conflicts.